Hi, good evening, Misty Witenberg.
I just wanted to remind council that last year we were considering cuts to social services, community health, and other programs. That was to balance our deficit, which is not resolved, it's increasing. So how could the city even put this list of cuts forward with any good conscience, knowing that we had just added millions upon millions of dollars to this project's capital cost and scope based on requests by donors? A single donor requested a weight room, training station, offices for donor staff, for 5 annual installments of $100,000 that can be canceled anytime. Who did the cost analysis that say that that was better for us, that that provided us any sort of fiscal advantage? Project that's advancing now that you don't even get to vet or say no to. Anyone want to acknowledge that last week, and I know you weren't all here, that there was a discussion where more consideration was given to potentially inconveniencing a donor's game schedule? Here's at least one of you up there is the parent of a Beacon Academy student, a student. If you were to diagram that contribution on our new state-of-the-art gym floor, they're paying for the center court line. But for that, they get signage that says it's the home of the Beacon Academy Wolves. Contribution barely covers Beacon's contingencies. The city issued 50 media releases, e-newsletters, and opt-in update. There was only one community meeting hosted by the city, noticed in those releases. We were told then that it was too late to address our concerns. None of those releases gave us any notice on the 2 debt ceiling increases to pay for the project. None gave us any notice of the bond hearing. The projections you gave us entirely exclude 2016 and 17 bond debt and 2018 and 19 Series B funding, all of which is backed entirely on our property taxes. This is the same thing that happened with the 3rd turf field or having turf fields at all. The costs escalated substantially, particularly with the project's aggressive timeline have been driven exclusively by donor and corporate interests. None of these have been by general public interest. We've showed a lot of concerns about the turf fields, environmental, health, safety, the fact that every 8 to 10 years we have to pay to replace it, dispose of it, throwing 200,000 square feet of turf and landfill and infill into landfills. Who here tonight is going to be advising you on these public interests? The West End's Open Space District. It was budgeted, leased, and approved for the restoration and preservation of green space as an expanded park. The zoning laws are not unclear here. I wanted to speak to the $1.25 million settlement in which the city is not admitting liability in the Crosby case. I urge you to insist that we admit liability. Instead of apologizing to this young man, we pursued charges against him that even officers on the scene had said they knew were going to fall apart, and that was at taxpayer expense. Most of the settlement is for reputational harm. We repeatedly smeared him, and we used city platforms to do that. Would we release the dash cam video? We perpetuated charges against him that he'd been acquitted of 10 months before. Who's advising these decisions that keep adding zeros to settlements? And protecting the city from having to admit when it's wronged members of the public is not in the public interest. Taxpayers pay the salaries of 4 staff attorneys and outside counsel, and when public interest and corporate interest conflict, we're funding people working against our interest. The proposed citizen comment guidelines and more broadly the increasing restrictions we put on public speech so far this year. You're missing the very real and measurable threats you pose when you refuse to address resident concerns. Residents are telling you that we're not being heard, that we're being shut out of the public process, and your response was to further constrain our opportunity to participate. So the outcome of that is not going to be decorum and order. That's just not a thing that happens in millennia of history. You're not advancing civility, you're driving civil disobedience. So if you want us to respect the system of public service, you have to serve the public respectably. It's difficult to look at this and not also see how a lot of these look like they're retaliating or giving some preemptive defense against issues that and initiatives that residents have brought forward, have done on their own. Just doesn't feel great when public is engaging and participating, and like you guys are trying to, limit efforts being made to open up engagement or to, allow citizens to exercise their rights. Ensuring compliance with the Open Meetings Act, that is stated directly in this jurisdiction, and it's been totally ignored. Asking how many FOIA requests were denied last year, in full or in part, by the law department before being forwarded to the FOIA officer. So the answer was 40%. 40% of hundreds of records, actually more than 1,000, almost 1,300 records. So I went to the clerk's office and I spoke to basically everyone there on staff, and they know that records are being unlawfully denied. They can't release the records in these cases because the law department is withholding the records from the clerk. Mayor, you spoke earlier about public trust. How can we trust the city when you're ignoring laws and laws of the state when it comes to transparency and rights? And you know this in the letter to the state's attorney alleging the clerk's official misconduct. The letter alleges that, quote, Reed has openly taken a position advocating for the open disclosure of city records in response to FOIA requests. Contrary to the direction of the city, the law department did not have authority to issue those directives. What was failed to be mentioned was that the complaints were filed in retaliation for the clerk reporting the corporation counsel, and her complaint cites that explicitly. And I think you all know that I firmly believe the city should hold city staff and officials accountable when they violate laws or break our council rules. And I'm sure you probably realize, Mayor Haggerty, tonight that you are in violation of Council Rule 18.11 in bringing SP8 as a special order of business. So fundamentally, you're violating council rules to censure someone for violating council rules. And if council took this vote in closed session, you also violated OMA to censure someone for violating OMA. I assume you are putting yourself up next for censure, except neither council rules nor city code authorize council to censure the mayor or the clerk, and you are charging someone with legal violations and attempting to impose penalty without even affording option of a hearing. That is the core requirement of due process. But you can't keep ignoring and selectively applying laws and process. If he's broken a law, I hold him to the same standard to which I would hold any of you. I'm here to address free speech. Say that I agree with you wholeheartedly that everyone up here, everyone in this room has a right to free speech, as does the Supreme Court. That was determined in 1968, Pickering versus Board of Education. You granted unlimited, unconstrained, and uncensored speech for every speaker who is supportive of your resolution. Speech and speakers critical of were constrained in 90 seconds or censored by content. So when they are engaging in free speech, that is a citizen right. They are under the same constraints we are.
Yeah, but there's also order in our meetings. I have my freedom to speak, and I'm going to speak right now.
Time, place, manner restraints have to apply to every speaker, has to be even-handed. Where there are exceptions, they don't exist here. You do not have the right to free speech as a public official. Your right is as a citizen. I want to finish by saying I didn't get to speak on Kevin Brown, but I do know he is the reason why children no longer get shot in the alley 10 feet from my house. It's just repeating between Suzette Robinson, our clerk. This process you guys have is not a fact-finding mission. It's to get rid of people who blow the whistle on things you don't want out. In response, the law department sent me the entire unredactable HR log showing the city hires an outside law firm exclusively to investigate Black employees, entirely disregarded the public's correct concerns. A lot of the items are not within the stated jurisdiction of this committee, encroaching on powers of independent branches. You do not receive quasi-judicial or adjudicative immunity because you are precluded from those functions expressly. I wanted to tell you what the legal department said about your authority to do this. Quote, the Rules Committee's jurisdiction does not include the power or authority to make administrative decisions. Jurisdiction and authority must be found within the provisions of the statute. So there's not a statute that even creates the Rules Committee. It is just city council. Ethics ordinance. So you guys, this new one you did, it removes all the language we just added in 2005 to comply with the State Ethics Act. You reduce the fine for violations of the Gift Ban Act provisions to $900 below the minimum required by the state. It also requires violations be treated as ordinance violations, because they are, that complaints be referred to the city attorney for prosecution, not defense. But who's not allowed to do it is city council. That's 536 of Illinois Municipal Code, which expressly precludes those administrative powers for you to practice. This ordinance makes council the final decision maker, also somehow its own board of appeals and levier of fines, but fails to provide any procedure affording parties due process, and specifically removes council's requirement
to act impartially, even in ethics cases. That's page 362. This ordinance reassigns the only executive and legislative oversight we have in our government into the hands of those officials. So I will conclude by asking any of you who are supporting this tonight if you can give us your argument of where in the last 5 millennia of government it has been a deterrent for ethical misconduct to concentrate power.
Substantiation for that statement. What we think is that when our city acts unlawfully or otherwise against public interest, we have the right and the duty to hold you accountable. Consistently refuse to be accountable or even acknowledge facts and data not advantageous to their positions, no matter how it harms constituents. That you are attempting to detract from what is, in fact, the reality that you have used your position to push and vote on a project and funding in which your family will personally and privately benefit above that of the general public. Minimized public concern by saying it's limited to a small number of people. I'm wondering your basis for this. It directly contradicts what we've seen in petitions, public comment. If you wanted to gauge public sentiment, you would have held a referendum. You would be broadening participation channels. You've done the opposite. This marginalizing, this othering of residents, to be clear, the threat limiting public participation that is on record and reinforced week after week is that if you speak out against certain council members, they will use their power to disparage and defame you. You keep blaming these issues on civility. Civility does not work when you are simultaneously subverting the civil processes the public has to hold you accountable. FOIA, OMA, ethics, which you refuse to substantiate despite civil requests. Thank you.
Thank you, Ms. All right.